propriety of the public parade of suspected criminals before trial is our focus on today's edition of Law Weekly. We'll also get the perspectives of some lawyers on the freedom of the press and the media's professional code of ethics, especially against the background of the recent detention of some journalists from the leadership newspapers. Before we delve into those issues, though, let's do a recap of the top stories from the courts. I'm Shola Sheyele, and this is Law Weekly on Channels Television. We begin with the report that the Economic and Financial Crimes Commission, EFCC, last week, Wednesday, rearranged 7 former police pension officials before Justice Hussein Baba of an Abuja High Court. The 7 suspects include Mr. Abubakar Kigo, a permanent secretary in the Office of the Head of Service, and Mrs. Uzoma Cyril Atang, a director of Finance and Accounts in the Ministry of Communications. They were arraigned on an amended 20-count charge of criminal breach of trust and conspiracy involving the sum of 29.8 billion naira. The offence is punishable under Section 97 of the Penal Code Act, Cap 532, Laws of the Federal Capital Territory of Abuja, Nigeria, 2007. The accused persons had earlier been arraigned before Justice Mohammed Tauba, who sentenced one of them, John Yusufu, to a 2-year jail term with an option of paying a fine of 750,000 naira, a move which was largely criticized by the public. Justice Tauba is currently being investigated by a panel of the National Judicial Council, with Justice Hussein Baba now hearing the case. While that case was going on, the former chairman of the ad hoc committee on fuel subsidy regime, Honorable Farouk Lawan, and the secretary of the committee, Boniface Emenalo, also asked another judge of the same court to quash the charges brought against them by the EFCC. The duo were charged with receiving $620,000 from businessman and chairman of Zenon Oil and Gas Limited, Mr. Femi Otedola, as inducement to influence the report of the committee in favor of his company. The accused persons contend that the prosecution has not legally made a case against them since it failed to provide the statements of its witnesses in support of the charges. The EFCC has described the move to quash the charges as a ploy by the accused persons to thwart and stall their trial. On the 2nd of May, Justice Mudashiru Oniyogi will rule on the application to quash the charges. From Abuja, we move to Lagos, where the High Court sitting in Ikeja continued its trial in the case of the murder of 25-year-old Cynthia Osokogu. A consultant pathologist, Professor John Obafunwa, has told Justice Bisi Akinlade that the deceased was gagged and choked to death. The pathologist who conducted an autopsy on the body of the late Cynthia also dismissed insinuations that the injuries sustained by the deceased were self-inflicted. 4 men are standing trial for the alleged murder of the late Cynthia, an incident which occurred last year at the Cosmila Hotel and Suites in Festac Town, Lagos. Trial of the suspects continues on the 24th of May. Still at the State High Court in Lagos, another judge, Justice Adeniyi Onigbanjo, last week Friday, rejected an application by the former managing director of the defunct Intercontinental Bank, Mr. Erastus Akingbola, seeking permission to travel abroad for medical treatment. The court held that the applicant had not shown evidence that there was no medical institution in the country that could treat him. Justice Onigbanjo also held that Mr. Akingbola was a flight risk after having heard the weight of the evidence against him in the case. The evidence had been led in a previous trial before Justice Abib Abiru, whose elevation to the Court of Appeal aborted the delivery of judgment. The trial of Mr. Akingbola and his co-defendant, Bayo Dada, continues on the 10th of July. And we round up at the Federal High Court in Lagos. The trial of the Speaker of the Lagos State House of Assembly on charges of laundering about 500 million naira was stalled last week Tuesday following the withdrawal of the Chief Prosecutor for the EFCC, Mr. Godwin Obla. Mr. Obla premised his withdrawal on his heavy schedule, which he says would not allow him diligently prosecute the matter. Justice Okechukwu Okeke has adjourned till the 24th of April to enable another counsel prosecute the case for the EFCC. Some lawyers have, however, hinted that Mr. Obla's move might not be unconnected with Justice Okeke's pending retirement in May, a situation which would cause the case to start afresh before another judge.
see, life has just got easier. You stay connected to Channels TV, where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
channelstv.com. The news at your fingertips.
Welcome back. The parade of suspects by the Nigerian police has become a permanent fixture on our television screens. But is the practice actually legal? Well, that's the question this next report attempts to answer. It is standard practice everywhere in the world that when people commit crimes, they are arrested, charged and prosecuted. No matter how heinous the crime committed, suspect prosecution follows basic rules and principles that are in place to protect the suspect's fundamental human rights. These principles go a long way in ensuring that a suspected criminal is treated with respect and dignity until his culpability is determined. However, in Nigeria, one issue that has continued to generate serious controversy is the issue of public parade of persons suspected to have committed crimes. Oftentimes, the police is shown parading the suspects to members of the press. The faces of the suspects are clear and broadcast for the whole nation to see. Their story is featured on all the major television networks and even the newspapers, with the names, age and occupations of the suspects also disclosed.
First of all, it is wrong and very, very wrong to parade a suspect, because when you do so, you are infiltrated into his fundamental human right. The best you could do is to obliterate his face and then allow him to speak. Because when you parade him without allowing him to speak, the whole world will not be in the position to know what is on his mind. Because when you parade suspects, while parading those that actually committed the offense, you may end up parading the innocent ones. By the time the innocent one is cleared, how do you get back to the world to tell them that indeed Mr. A or Mr. B have been cleared? And that is why it is wrong to parade suspects.
The police, you may not blame them in some cases because there are a lot of allegations leveled against the police. Sometimes they do this to protect their own image and interests. So we have to look at it holistically. If their hands are tied or if they are under severe pressure and there are rumors that, oh, look, the police is doing something, covering up, you don't blame them if they come before the camera with all the suspects. For example, if they accuse the police of releasing a criminal. You understand what I'm saying? There are many situations where sometimes they have to do that to clarify facts and any ambiguity.
The law says you are presumed innocent until proven guilty. That's why I said that they can parade, but they will blur the face so people don't see the identity of the person. Because if you parade me today as a criminal and at the end of the day the court discharges me, you've already paraded me. Though they attempt suspects, they are not being convicted, but then it's still also wrong to put my face on TV.
One of such parade that has generated outcry from the public in recent times took place in Abeokuta, the capital of Ogun State. There, the police paraded a 2-month-old baby, his mother Fausat, and his 15-year-old brother over an alleged robbery committed by their father Ismail. The family was arrested after the suspect fled his home. The Ogun State Police Commissioner reportedly told the media that Fausat and her teenage son were arrested for allegedly keeping a gun for her husband. However, Fausat claimed that she was no longer married to the suspect and had consistently asked him to get rid of the gun. She added that one of the suspect's brothers had been in the process of removing the gun from their house at the time of their arrest.
By the time you are arrested and you exhibit any element of resistance, it's taken to mean that, look, you are resisting, you're fighting the police or fighting some other person. That becomes a different issue, and you may be purely innocent of what you're being accused of, but that could become another issue over which you may not, go free. So almost always, such people are never in that strong position to resist. Never. They are never.
But when they eventually are paraded and then found to be innocent and released subsequently, what remedies, can they bring any action to say that?
Yes, of course, their rights have been violated, and usually they're entitled to a public apology by the police for that wrongful act. And if they have suffered, pecuniary or physical or health damages, of course, they're entitled to pecuniary damages. They can apply to enforce their rights for such violation, and they will get compensation. Really. But well, some will do it. Some may just quietly go home and say, look, thank God I'm free. But
however, the practice of parading suspects is not unique to Nigeria. In the US, for instance, while it is common for arrested suspects to be concealed from public view while in police custody to protect their privacy and reputation, it is sometimes unavoidable after they have been charged to court to expose them to the public while being transported through public places. This is known as prep work. The prep is short for perpetrator and could be used as an opportunity by the police after a charge has been laid to parade the suspects by tipping the media and the public of the planned work. After charges were laid against him, Lee Harvey Oswald, the presumed assassin of US President John F. Kennedy, for instance, was paraded in front of TV cameras several times as he was moved from place to place in Dallas Police Headquarters and was even allowed occasionally to speak to the media. He was shot dead in one of such pep walks by Jack Ruby while being led to a vehicle for transfer to the county jail. In the UK, name and shame, a practice aimed at discouraging antisocial or criminal activity by publishing the names of those involved, is not very different from parading suspects. The UK uses the name and shame policy variously, including against shoplifters, abortionists, graffiti artists, and customers of prostitutes. In fact, the Rat Book, the UK's biggest name and shame website, which was launched in late 2009, contained as at January 2010 the details of over 14,000 criminal charges and convictions on sundry issues including pedophilia, rape, murder, violent crime, abuse, and terrorism. A major difference, however, between the parade of suspects in the USA, UK, and Nigeria is that the investigative process is so robust in those other countries that often the police and authorities would make an arrest only when they feel they have sufficient evidence for a successful prosecution. Here in Nigeria, law enforcement agencies often do the opposite. They arrest first and then fish for evidence to prosecute afterwards. While there are legitimate and legal concerns about the practice of parading suspects before trial, because there is the presumption of innocence until convicted by a competent court of law, the practice is also seen as a breach of a fundamental human right. The Universal Declaration of Human Rights provides in Article 10 that everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal in the determination of his rights and obligations and of any criminal charge against him. It also states in Article 11 that everyone charged with a penal offense has the right to be presumed innocent until proven guilty according to law in a public trial at which he or she has had all the guarantees necessary for his defense. These rights are there to ensure that all people are treated with dignity and fairly no matter what crime has been committed by them. The rights have also been incorporated into Section 36, Subsection 5 of the 1999 Constitution of the Federal Republic of Nigeria. So, it is the duty of the prosecution who alleges that the accused person committed the offense to prove it beyond reasonable doubt. But is that the case in Nigeria today? Do the police in the prosecution of cases against citizens follow the provisions of the law as laid out in Section 36, Subsection 5, or do they, in their zeal to show the people that they are indeed hard at work, create a situation where human rights are totally disregarded?
you're not a criminal until the court determines that you're a criminal. So parading suspects is almost like making a statement that these are criminals. Or the court hasn't determined it, so why will you parade? If you can do identification parade, for instance, and that is confined only to the police station or even in the prison, and that only comes in where you have witnesses to identify. There's no other sane society where suspects are paraded. No other sane society. And also, it's not one that can be accommodated under our law. So whatever the police right now are doing, they're doing so without recourse to recognizing the rights of the suspects and recognizing the current position of the law. So it flows from ignorance, it flows from lack of knowledge as to what the law is concerning the rights of the people that they are parading.
This argument that Nigeria is a disbelieving public and the police need to show, maybe by parading the suspect, that they are working. Is there any justification for that?
There's no justification for that. If you're working, we will know from your works. You don't have to parade. So what you're now doing is you're now working to the answer. So you can arrest anybody on the street and parade the person to show that you're working. Meanwhile, it is the court that will determine whether that person that you have arrested is guilty or not. Recently, I was reading in the papers about a comment accredited to a commissioner of police. I don't know whether he said Edo State or so, who said that they are on to the trail of the people who murdered the special advisor to the governor of Edo State. Now, why will you go to the press to say such a thing? If you're on to the trail, assuming that the people are in the dark, now you come to the public to make such a statement, is that not to alert them so that they bolt, that the investigation is almost catching in on them, that the police is closing up on them? Is that not enough for any suspect to? So one has to really be careful the way you come across in terms of the power you enjoy as regards investigation and enforcement and arrest of suspects. No one is a criminal until the court determines the person as a criminal. So it is the duty of the court to determine. Now, when the court now confirms, when the court now convicts, then you can come on air and simply say, oh, this is what you've done.
Questions, but I do hope that you found some answers in that report and that the relevant authorities reevaluate this practice of parading suspected criminals. On the home stretch, we look at the issue of press freedom and two interesting perspectives.
The recent arrest, detention and subsequent release of 4 journalists from the leadership newspapers by the Nigerian police in connection with a story on a purported presidential directive on dealing with the opposition has once again brought to the fore the issue of press freedom and media professional code of ethics. On the 3rd of April, the newspaper had published a story with the headline, "Outrage Trails Presidential Directive on Tinubu APC." It followed up the next day with the publication of the full text of the purported presidential directive. Though the government has come out through its special advisor to the president on media and publicity, Dr. Reuben Abati, to state that the president has no hand in the detention, it however noted that the bromide story was capable of causing civil strife, engender a breakdown of law and order, and negate the values of democracy, which is a very grievous act indeed that should not be ignored.
I published an article in my newspaper sometimes 2006, and the administrator of Ekiti State, then General Lure, felt embarrassed at the article and lured me, not this time not arrest, lured me to the state under the guise of wanting to say his own side of the story, and I was subsequently handed over to the State Security Service officials. I was there, detained there. No statement was taken from me, except that I was asked to give a biodata of myself and how I wrote the story. And nothing more until the administrator left 17 days after. That was when I was released.
Section 36, subsection 1 of the country's 1999 constitution guarantees freedom of the press in Nigeria. It stipulates that every person shall be entitled to freedom of expression, including freedom to hold opinions and to receive and impact ideas and information without interference.
What is without? When the same constitution allows for a derogation of those rights. But in any case, Nigerian journalists have taken advantage of that Section 36 then, in 1981. And they made publications. Some of the publications turned out to be very contentious to the government of the day in 1981. And the government has had call to invite those journalists. I remember vividly. The first is the case of Innocent Adiuku, Eric Teniola, and Punch on one side versus the House of Representatives. 1981. What Punch published was that some members of the House of Representatives in 1981 were pocketing salaries and emolument for non-existing workers. And of course, the members of the House of Rep felt outraged. Okay, what the House of Rep member did was, okay, after reading, they now invited the journalists. Come to National Assembly. We have the power under Section 82, 83 of the Constitution to invite you in the course of our investigation. Please, come and tell us who amongst us is collecting salary for ghost workers. Of course, the journalists will never take kindly to that. They ran to court. And Justice Balogun took up the case. Justice Balogun of the Kejara Court. Justice Balogun, in his intellectual erudition, reviewed the American constitutional law, case laws that were decided on similar issues, reviewed the British position, and came down heavily to say, well, in those American constitutional law cases, there have even been dissenting opinion, conflict of opinion, but that he was persuaded with the minority view which favors press freedom. And that was what the judge used in that case, and to say, well, you, House of Rep member, you can only compel a journalist in Nigeria to disclose his source of information if you are doing so pursuant to national security. Although the right of journalists were upheld, but not in absolute terms. You see, give leeway to the government to inquire, particularly when a crime has been committed. Don't forget that the police have the right and statutory responsibility under Section 4 of the Police Act to investigate any crime that has been committed in Nigeria. It can invite anybody.
There must be a distinction between police investigation and arrest and detention. When you publish a story and police feel that their story is contrary to national security or threatens national security, the police can invite you and ask you questions about what you publish. And of course, you have a right not to disclose your source of information. Now, that invitation should be cordial. It should be an open space. It should be free. It should be conducted not as an interrogation, but as an invitation for discussion. Now, of course, that question, once it goes into hours and you detain people, you keep people in the police station hours, getting to the next day, of course, that is an arrest and detention. You cannot question people, invite them for hours. And once you arrest people, you're actually subtly manipulating them, treating them for them to answer your question. So inviting people, there's nothing wrong with police inviting anybody. The police can invite anybody in furtherance of the investigation. They have the right to do so. But when you now get into arresting them for purpose of that investigation, that's a problem. Because what you're doing really is that you're sending a message to other journalists that once you publish anything you're not sure of, then we're going to invite you and ask you a question. In any event, who defines when a document is forged or not? I mean, journalists can publish anything about my organization, and I'll come out and say, well, that is a forgery. Where do you get it from? But who defines that? It is not. It is until investigation is conducted and it is found out that that document was actually forged, then that becomes a difference. That investigation should not start with the journalist. It will start with the other organization that is alleging that it is a forgery. They should say, who do you think forged it? And then they'll start the investigation from there, not from the journalists that published it.
So let's look at this story as concerns leadership newspapers now.
Yes.
What do you make of the way it has been handled? Subsequently, how could it have been?
Well, first, it is wrong for the police to arrest the journalists, because I maintain that they were arrested, they were invited and stayed. 2 were released after about 7 hours, the other 2 released after 24 hours. That was an arrest. Now, arresting them because they published a story based on information received from the presidency is the highest level of muzzling the press by the executive. I mean, if the presidency feels that the story published is wrong, They have media advisors. All they can do, they have legal advisors, they have attorney general. All they can do is to go to court, to sue leadership newspaper in court, and join the journalists that publish the editor, and ask the court to force them to disclose the source of information. It is the court that will make an order in that respect. It's not the police. They cannot use the police to intimidate people who are carrying out their professional and constitutional responsibilities. It is not done. Because once we start doing that, then we'll kill free speech.
Well, that matter is still under investigation and the newspaper has threatened to approach the courts. That's the program this week. Thank you for watching and do tune in same time next week. I'm Shola Shayeli.